I want you to picture a scenario, and I think it's pretty much the modern equivalent of purgatory.
Oh boy.
You're standing in a hallway. It smells, faintly of bleach and old paper. You're holding a token, number 405, and the screen is stuck on, like, 12. You need a permit or maybe a refund, or you're a government employee who's been waiting 3 years for a promotion that was promised in an email no one can find.
You are describing the universal experience of dealing with the state, that feeling of being a very, very small cog trying to turn a giant rusty wheel.
Exactly, that feeling of powerlessness. But we are not here to wallow today. We're here to, well, kind of hack the system. We've got these notes on administrative law dated January 9, 2026, and honestly, it's like the instruction manual for that rusty machine.
It really is. And I know administrative law just sounds incredibly dry.
Yeah, it sounds like something you'd study to bore people at parties.
Right. But it's actually where the most high-stakes stuff happens for the average person. It's not about murder mysteries. It's about the machinery of justice itself. How do we make the government keep its promises? How do we get around the courts when they take 20 years to decide something?
And that's our mission for this deep dive. We're looking at the checks, the balances, and, my favorite part, the shortcuts. We're going to talk about fake railway porters, government promises that just vanish into thin air, and a tribunal that can fine you 5 crore rupees for throwing a party on a riverbank.
It's a fascinating look at how the state tries, and I should say sometimes fails, to hold itself accountable.
Okay, so let's start with a concept that sounds super legalistic, but the story behind it is great. The doctrine of estoppel.
Estoppel. Yeah, the name itself, it kind of shuts things down. It literally means stopped or plugged.
And the notes have this perfect case from 1919 to explain it. Soames versus London and Southwestern Railway. It feels like a scene from an old movie.
It really sets the stage perfectly for the whole principle of representation.
So picture it. It's 1919. A passenger gets to the station, probably in a rush. He sees a guy in a full porter's uniform, the cap, the jacket, everything. This guy grabs the passenger's bag, walks him through the barrier, says, "I'll watch this," and the passenger thinks, "Great service."
A completely reasonable assumption. The man looks the part. He's acting the part.
Exactly. But then, poof, the porter is gone, and so is the bag. The passenger is furious, obviously, and he sues the railway. And the railway company's defense is, I think, pretty cheeky. They say, "Look, sorry about your bag, but that guy, he wasn't our employee, an imposter. So not our problem."
And, in a strict employment law sense, maybe they had a point. But the court just wasn't having any of it. They applied estoppel.
Because they let him just stand there in the uniform.
That's the absolute crux of it. The court basically said to the railway, you allowed this man to wear your uniform. You let him operate on your property. By your own conduct, you represented to the world that he worked for you.
So you can't just turn around later and say, "Oops, just kidding."
You're stopped. You are stopped from denying the truth of that representation. The passenger relied on what he saw, and he suffered for it. So the railway had to pay.
Okay, so that's a private company.
Yeah.
A business tricks you, they pay. But this is where it gets really sticky. Does this same rule apply to the government? Because, let's be honest, politicians and bureaucrats change their minds all the time.
And this is the real battlefield of what's called promissory estoppel. The answer is, it's complicated. The courts have had to drag the government kicking and screaming to accept this principle.
The notes point to this huge case in 1968, Union of India versus Anglo-Afghan agencies.
Oh, this is a landmark. So the government wanted to boost exports, right, to Afghanistan. They put out a public scheme that said, if you export woolen garments, we promise to give you an import entitlement certificate for raw materials equal to 100% of the value of your export.
That is a huge incentive. The government is literally saying, spend your money now, we'll pay you back later in tax-free imports.
Exactly. So this company, Anglo-Afghan Agencies, they looked at that and went all in. They exported a massive amount of wool, but when they came to collect their certificate, the textile commissioner just said, well, we've decided to scale that back. You're not getting the full 100%.
A classic rug pull.
Total rug pull. Thanks for your help, but the deal's changed. The government argued it wasn't a formal contract, just, a policy statement, that they could change it whenever they wanted.
And the Supreme Court said?
They completely shut the government down. They ruled that even without a formal contract, the government was stopped. They said, you made a promise, a citizen acted on that promise, altered their position, spent money. You cannot just revert to the old position because it's convenient for you.
That feels like a massive win for the little guy. A press release could be as binding as a contract.
It is a win, but, and you knew there was a but coming.
There's always a but.
The government isn't a private company. It has a duty to the public that a railway company just doesn't. And so the law gives the government these escape hatches.
Of course they have escape hatches. Okay, what are they?
Well, the first one is pretty straightforward. You can't use estoppel to force the government to do something illegal.
Okay, that makes sense. If some official promises me a permit to build a casino in a school zone, a court isn't going to enforce that.
Right. A promise can't override a statute. No estoppel against the law. The second is fraud, which is obvious. But the third one, this is the big one, public interest.
Ah, the ultimate trump card. It's in the public interest.
It is the trump card. The courts have basically said the government can't be stopped from exercising its legislative or sovereign functions. If the government can prove that breaking its promise to you is necessary for the greater public good, the court will let them do it.
But that sounds so vague. Couldn't they just claim anything is in the public interest to get out of a bad deal?
That is the danger, and that's where the legal fights are. The notes mention another case, Kizarum Industries, where the court said just sort of hoping a policy continues isn't enough to claim estoppel. But the general idea stands. Private interest has to yield to public interest. A government can't be tied down by old promises so much that it can't govern.
So if you do business with the state, get it in writing, make sure it's legal, and cross your fingers.
That's a cynical but pretty accurate summary, yeah.
All right, let's pivot from broken promises to, well, broken calendars. The regular courts, as we said, are a nightmare. I've heard civil cases in India can drag on for, what, decades?
It's not uncommon at all. The backlog is millions and millions of cases deep.
So the system needed a bypass. The notes talk about the Administrative Tribunals Act of 1985. This came from the 42nd Amendment. The idea was to create these express lanes, wasn't it?
Essentially, yes. They're quasi-judicial bodies, so they're not full courts, but they do have the power to decide cases. The biggest one mentioned here is the CAT, a Central Administrative Tribunal.
CCAT. Yeah. And this is just for service matters, right?
Right. If you are a union government employee, an IAS officer, a clerk, a secretary, and you have a dispute about a promotion, your pension, maybe an unfair suspension, you don't go to the high court. You go to the CCAT.
And the main benefit is speed.
Speed and expertise. And here's the really interesting part about how they get that speed. They are not bound by the Civil Procedure Code, the CPC.
Whoa. So for anyone listening who isn't a lawyer, the CPC is like the giant rule book for how a trial works, right? Evidence, witnesses, all that.
It is the very thick, very rigid rule book. It's meant to ensure fairness, but it also guarantees delay. The CAT just sets it aside. They operate on the principles of natural justice. It's a much looser, more flexible way to get to the truth without all the procedural red tape.
That sounds good in theory, but look at who's on these tribunals. The notes say the bench is a mix of judicial members, so judges, and administrative members.
Yes. Administrative members are usually retired senior bureaucrats, people with deep experience in governance.
But hold on. If I'm a low-level employee suing the government, and one of the two people deciding my case is a retired senior government boss, isn't that a bit like the fox guarding the henhouse?
That is a very, very common criticism. The argument is that they could be biased towards the state. But the counter-argument is that regular judges can live in an ivory tower. They don't know how a government department actually works. An administrative member knows the reality of the files, the hierarchy, the internal politics.
So it stops the court from making a decision that sounds good on paper, but is totally unworkable in reality.
Precisely. It brings a dose of reality into the courtroom.
Okay, so CI is for the bureaucrats. But there's another tribunal in these notes that I think has a much bigger impact on the rest of us, the NGT. The National Green Tribunal.
Ah, this one is a favorite of mine. When the NGT Act passed in 2010, it was revolutionary. India became only the third country in the world, after Australia and New Zealand, to have a dedicated environmental court.
I did not know that. That's a surprising statistic.
It shows you how serious the intent was. And unlike the civil courts, the NGT is aggressive. It handles cases under the Water Act, Air Act, Forest Act. But its key power is that it can initiate suo motu cases.
Right, suo motu. That means they don't have to wait for someone to complain.
Exactly. A regular court is passive. It waits for you. The NGT can read a newspaper story about a lake in Bangalore catching fire or illegal mining in a forest, and they can just start the case themselves. They become the prosecutor and the judge, in a way.
It turns them from a referee into a watchdog. And they run on the polluter pays principle.
Which they take very, very seriously.
The notes bring up the Art of Living case from 2017. That was a huge controversy.
Oh, it was massive. The Art of Living Foundation held this enormous cultural festival right on the Yamuna floodplains in Delhi. Environmentalists were screaming that it would destroy the ecosystem. The event went on, but the NGT dropped the hammer afterwards.
A 5 crore rupee fine.
As environmental compensation, yes. And it sent a shockwave. It was a signal that even culturally important, politically connected groups are not immune. You damage the environment, you write a very big check.
But, and I have to be the devil's advocate here,
Mm.
did the river actually get fixed? A 5 crore fine is a great headline, but does the floodplain recover?
And that is the ongoing struggle. The NGT is fantastic at stopping things like the plastic ban mentioned in the notes. For bags under 50 microns, they can halt industrial activity, but restoration, that's much harder to enforce. They can order the cleanup, but they're still relying on local authorities to do the work. And local authorities are, well,
Where efficiency goes to die.
that's the perennial problem, yes.
Okay, let's talk about the other truth-finding bodies in the notes. Commissions of inquiry, we see these all the time. Government appoints commission to probe X.
Right. Set up under the 1952 Act, they're temporary bodies appointed to investigate a definite matter of public importance.
The notes list some huge ones. The Librahand Commission on the Babri Masjid demolition, the B.N. Sri Krishna Commission on a whole Telangana statehood issue.
And on paper, these commissions have serious power. The powers of a civil court. They can summon witnesses, seize documents, demand secret files. They can really drag the truth out into the open.
But here's my problem with them. We wait years for these reports. The Librahand Commission took, 17 years?
It took an incredibly long time.
And then, what happens? Does anyone actually go to jail because of a commission's report?
Almost never. And that is the design flaw, or maybe the design feature of the system. A commission of inquiry is a fact-finding body. It is not a criminal court. Their reports are purely recommendatory.
Recommendatory. That's a polite word for optional.
The government can take the report, say thank you very much, and put it in a drawer. They're under no legal obligation to implement the findings or prosecute anyone named in it.
So are they just political theater? A way to let public anger die down while a retired judge writes a really long book?
A cynic would definitely say yes. They act as a pressure valve. Something awful happens, the public is rightly furious, the government says we're appointing a commission, and it feels like action. By the time the report is out 5 years later, the public has moved on.
That's just incredibly depressing.
It can be, but there is value in creating the record. Even if no one is punished, having an official judicial-level document that says, this is what happened and this is who was responsible, that matters for history. It establishes a truth, even without the satisfaction of a conviction.
I guess truth has its own value. Okay, finally, let's just touch on these business hybrids. The notes mention public corporations.
This is where the government tries to act like a business. We're talking about huge entities like the LIC, ONGC, the Damodar Valley Corporation.
And why do we need these? Why not just have a government department run them, like the police or something?
Because bureaucracy kills business. I mean, can you imagine if an oil company like ONGC had to wait for Parliament to approve its budget every time it wanted to buy a new drill bit? It would collapse.
So they create a separate legal entity.
Exactly. They're created by an act of Parliament, they're owned by the state, but they have autonomy. They have their own money, they make their own decisions, and crucially, they can sue and be sued in their own name.
That sued part seems important. If the railways loses my bag, I sue the Union of India. But if LIC denies my claim?
You're suing the Life Insurance Corporation of India. It separates the commercial risk from the sovereign state. But, and the notes are clear on this, because they are state-owned, they're still subject to judicial review. You can file a writ against them if they violate your fundamental rights. They can't just act like a ruthless private company.
So if we bring this all together,
Yeah.
we've got this whole machinery. We have Estopol to stop the government from, gaslighting us. We have tribunals like CTAC and the NGT as express lanes for justice, and commissions to find the truth, even if they can't punish anyone.
It paints a picture of a system that is, I think, painfully aware of its own flaws. The state knows it's too big, too slow, so it builds these little annexes, these tribunals and commissions to try and keep the whole thing from falling down.
That's a bit of a patchwork quilt, isn't it?
It is, but it's a quilt that allows for some accountability. Without these mechanisms, I think the citizen would just be completely crushed by the sheer weight of the administration.
So for you listening, the takeaway is, know your lane. If you're a civil servant, you have the CAT. If you care about pollution, watch the NGT. And if a politician makes you a promise,
You might want to check if it's in the public interest for them to break it later on.
That brings me to the thought I want to leave everyone with. We talked about how public interest is the government's escape hatch for promissory estoppel. The notes say, promissory estoppel cannot be invoked to prevent the government from discharging its duty under the law. It really makes you wonder. If the government can just pass a new law or declare a new duty that cancels out its previous promise to you, is any contract with the state ever truly safe? Or are we all just relying on the government's good mood?
That is the fundamental tension, isn't it? We want a government that keeps its word, but we also want a government that's powerful enough to change course when the world changes. You can't have both perfectly.
A comforting thought for anyone holding a government bond right now.
Indeed.
That's it for this deep dive into the machinery of the state. Thanks for exploring the fine print with us.
Stay curious and always read the terms and conditions.
We'll see you next time.